Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public. So please subscribe to our channel. Today I want to talk about the interplay between remarriage and alimony or spousal support obligation. Just historically speaking, going back to, let's say, we don't have to go back forever. Let's say we go back to the 50s or the 60s. The concept of alimony was a pretty familiar one. A lot of times the husband would be the breadwinner, the wife would be the homemaker. In the event of a divorce, of a marriage of decent duration, there would be an alimony award. There would be an award of some level of support to help the wife who was not in the workforce somehow maintain her ability to sustain herself. So there'd be alimony. How long would the alimony go? Well, in judgments from 30 or 40 years ago, a lot of times you'll see the language that it'll say the alimony will continue until death or remarriage of the receiver of that alimony. So the concept being that if somebody was getting alimony but then remarried, their need for support would terminate because they would be supported by their new spouse. And if that's the case, then it would support that. Now you don't see language like that. In most cases, a spousal support or alimony provision will say that it continues until further order of the court based on a significant change of circumstances. It might not even say those words. It might just say until further order of the court. But what that really means is that somebody can come before the court and ask for a further order. What is the reason why the court would grant a further order? What's the reason why they might modify or change the alimony provision? The answer is a significant change of circumstances. That's the reason why the court would do it. So the format is that somebody is paying alimony. They would then contact their lawyer and say, I can't pay it anymore because it was based on $100,000 a year. I'm only making $20,000 now because I've been laid off. All I get is unemployment. Just a wild example. So the lawyer then has to file a petition to modify the alimony or suspend it. Well, in order to have any hope that that motion will be granted, that attorney is going to have to set forth a change in the circumstance. Something new that has come up which no longer renders alimony as being feasible. And what would that new thing? In this case, it would be unemployment. Okay, so that would be a significant change in the circumstances so that the court could in fact change its prior order and say alimony is suspended until further order of the court. And then let's say he gets a job, he's making the same money. The other side of file a motion, further order of the court. Now we want the benefit of further order of the court because the circumstances change again. He's employed now. Maybe he's making more. Maybe he's making less. If he's making a little less, maybe there should be a modification, but that alimony should be put back. Now, what about remarriage, for example? Well, is that a significant circumstance? You can file a motion and say there's been a significant change in the circumstance. Why? She remarried and has ample support in her new environment. If that's the case, the court might well entertain a motion to modify the alimony. And of course, it's up to the court's discretion to determine if it grants such motion and to what degree. So obviously, it's very case specific. The key though is, has there been a significant change in circumstances? That's the launch point from which motions to modify or suspend alimony are initiated. Now, obviously, every case is different. You have questions about your case, reach out. We'll be glad to help you out.